American Legion versus American Humanist Association is a case about whether a Maryland county can continue to display a nearly 100-year-old cross-shaped war memorial that it originally put up to honor the people from that county that died in World War I. The case gets at fundamental questions about what it means to be neutral toward religion in a pluralistic society. The parties to this case are the American Humanist Association and 4 of its members that live in Prince George's County, Maryland. The defendants in this case are the government of the county and a group called the American Legion, which is a veterans organization. The Bladensburg Peace Cross is located in the middle of a busy intersection in Prince George's County, Maryland, suburban DC. It's actually also part of a veterans memorial park that's got other memorials also to past wars that we fought in. The Peace Cross was originally on private property. It was maintained by the private group that put it up. It was in 1961 transferred over to the government for traffic safety reasons. The government has maintained it ever since. This case started in 2014 when the American Humanist Association and 4 of its members filed this lawsuit. They said that they had driven past the cross and were offended by it. They were made to feel stigmatized by it, and so they brought the case. The Constitution, and specifically the Establishment Clause of the First Amendment to the Constitution, are at the center of the case. The plaintiffs say that a cross memorial on public property violates the First Amendment. The Establishment Clause was included in the Constitution because the founders didn't want the new federal government of the United States to have a church. And then in the 20th century, the Supreme Court held that it also applied to the states. I think the court has been thinking about a more originalist way of deciding Establishment Clause cases based on what the founders would have considered an establishment. So in a case called Town of Greece versus Galloway a couple of years ago, the court said you have to interpret the Establishment Clause based on historical practices and understandings. So in light of what the founders would have viewed as an establishment, and in light of long-standing practices. This case is going to be a case where the court is going to have to choose between going that historical route and applying the Lemon test. The Lemon test is a test that the court set out in a case called Lemon versus Kurtzman in 1971. And in that case, the court said that you can determine an Establishment Clause violation by looking at 3 things. First, does the government's action have a secular purpose? Second, does it have an effect that either advances or inhibits religion? And third, does it entangle the government with religion? There hasn't been any other case involving the government use of religious symbols since 2005. That year, it decided 2 cases about 10 Commandments displays. One case called Van Orden, one case called McCreary. And it handed down these decisions on the same day. One of them, they upheld the 10 Commandments display. One of them, they struck down the 10 Commandments display. And those 2 decisions generated 10 total opinions by the justices. So there's been a lot of confusion for 13 years about how to decide these religious display cases. American Legion's argument for the government is that the Peace Cross doesn't compel anyone to do anything or to have any particular faith. And it's surrounded by lots of other displays that are also all about war monuments. The best argument for the American Humanist Association probably sticks closely to the reasonable observer test. If anything that a reasonable observer would think endorses religion violates the Establishment Clause, the government can't use war memorials that are shaped like crosses because that makes people that don't share the beliefs, it makes them feel stigmatized and like outsiders. If the government wins in this case, then depending on how the court writes the decision, it could mean that we'll have some more clarity as to how courts are supposed to decide cases involving religious displays. If the American Humanist Association wins in this case, first we'll see a long-standing cross that's been there for nearly a century torn down. And likely we'll see lots of other cases pop up